fancy PowerPoint, but I do have notes. So what I'm going to do is give you a little bit of history of how we got here. Somebody entitled my presentation, What's Happening in Houston, teaching moment for our guests. Houston is not Harris County, and Harris County is not Houston. Houston travels into Montgomery County, it travels into Fort Bend County. Harris County, the third largest county in the United States, includes Houston, other municipalities, and all these unincorporated areas. And we have somewhere between 100 and 120 law enforcement agencies who arrest people and bring them to our jail. So you may be familiar with how all that works just from having done this work. You know, in Harris County, when someone gets arrested, the officer calls the district attorney's office and says, well, can we take this case? And they say yes or no. And if they say yes, the person is then either brought to that law enforcement agency's holding place, like the HPD has a city jail and various substations, or they could be brought directly to Harris County. And traditionally, that's where everybody ends up at some point. They end up at Harris County, what's called the Inmate Processing Center. At one point, it was in the Criminal Justice Center, which is our building. It's now been moved back across the street, across Commerce Street, and so everyone ends up there. They're processed in, and at some point, they become before a magistrate. And you're going to hear later from Janie about Texas law and what they're supposed to do, but that's the point where they get their initial bail hearing. And so when I first came to Harris County, I said, I'd practiced here many years ago. I went to South Texas, I got out, I practiced from 1985 to 93, and then I became a federal public defender for about 20-something years and only practiced in federal court. But I came back, I know the system, I know that they're not represented at those hearings, and when I first came back here, I started bringing it to the judge's attention and said, this is a problem, and there's a national trend toward representation at these things, and they would kind of listen to me and smile and know, just by me saying it, it wasn't going to happen. And I'd go to judges' meetings, and I'd say, here's what's wrong. We've been watching these videos. In fact, we had interns do it. I still have notes from Emma Cantu when she was an intern in our office watching the videos of these hearings, and these terrible things would happen. You'd have defendants incriminating themselves. You'd have magistrates getting upset and doing kind of inappropriate things about setting bail. And I'd go to the judges' meeting, and I'd say, look, these people are incriminating themselves, and, I'd get pushback. Some of the older judges, Judge McSpadden and Judge Collins, say, oh, they never used that. To his credit, and he was pretty much a brand new judge at the time, Ryan Patrick said, oh no, I used to use that all the time. So it was a clear problem, but I didn't really have any leverage to get it done. So how did we get to where we are now, which is having Commissioners Court not only agree to it, but pay us to do it? I wrote an article with Andrea Marsh for Voice for the Defense back in 2014, which was kind of my initial project of how you could do this, how you could set this up and have representation. Andrea was then executive director of the Fair Defense Project. You may know that name because they're one of the sets of lawyers that are suing the county and have sued the county in the federal lawsuit O'Donnell. But I didn't really get much traction with the court. So one of the things that happened back in 2009, that's when the jail was kind of at its peak. We had about 10,000 people. It was way overpopulated. They had to send people out of state to Louisiana and other counties to keep up. So they brought in a group, an outside research group called Justice Management Institute. And they did a study, and they made all kinds of recommendations about how to fix things. One of the recommendations was to set up a criminal justice coordinating council. They did that. One of the other recommendations was to have representation at bail. They did not do that. But the Criminal Justice Coordinating Council was a good thing, and when I got here, I was put on it. I'm a non-voting member, but I'm on the coordinating council. And so the council did things like we applied for a MacArthur grant. And that was kind of good in the sense that we had to sit down, I worked with all the elected officials, the DA, the judges, and we had to come up with strategies for how we're going to get this money and reduce the population in the jail, reduce racial disparity in the jail. And of course, my strategy was, well, we should get people represented at bail hearings. And that didn't go real well, except the night before the application was due, I got a call from one of the judges, I won't mention who it was, said, would you come down to my chambers? And we hashed out kind of a pilot project of representing mentally ill defendants at bail hearings. And that got into the final proposal. But when we were awarded the grant, they got a little less money than they thought, so they axed that out. So that went away too. But what's also going on at that same time is the county was starting to work with the Laura and John Arnold Foundation. Laura and John Arnold Foundation is based here in Houston. They're from here. Mr. Arnold made his money in Enron. They're very rich and philanthropic, and they got interested in a number of issues, but pretrial justice was one of their issues. So they developed this risk assessment that's now been used across the country, many states. You're going to hear about New Jersey, how they've applied it. Colorado, well, not Colorado, Kentucky, Arizona, a lot of major cities use it. And so we were very interested in getting that done. So that was also going on. And the thing about the Arnold assessment is Marie Van Nostrand, who some of you might remember came and spoke at South Texas when we had this other, kind of big countywide education about pretrial justice. She was the facilitator in those other districts to implement the Arnold assessment. She worked in New Jersey to implement the Arnold assessment, and she's been working here in Harris County to implement the Arnold assessment. And one of her big things is you got to have lawyers at initial appearance to represent defendants, because otherwise it's not a meaningful hearing. So I had her on my side too. And then the big thing that happened was the lawsuit, of course. The lawsuit kind of pushed everything forward because they weren't asking for having representation at initial appearance. That wasn't part of the lawsuit. That wasn't one of the things they were asking for. But what they were saying was, look, we've gone around the country and we've been pretty successful in getting counties to settle if, in fact, they have a strict bail schedule that they don't deviate from and don't take into account people's ability to pay. And so I think there was a slide before about the Alabama suit where they won a settlement. But this was going to be their first big jurisdiction, big urban jurisdiction where they were going to take a stand and maybe have to litigate it. So that lawsuit was filed. It was filed by Fair Defense Project and a group called Equal Justice Under Law. It's now called Civil Rights Corps. A guy named Alec Karakasanis is the lead counsel for that group. I know all these people. I've worked with them before. They also got a local law firm, Sussman Godfrey. Most of you know it's probably one of the most successful plaintiffs firms around, not just in Texas, but in the country, and brought that lawsuit against Harris County, and Harris County just didn't agree. They said, oh no, and this was just against the criminal law hearing officers, who are our magistrates, and the county court at law judges, who are our misdemeanor judges. Didn't touch felonies. And the purpose of the lawsuit was to require that they take into account people's ability to pay. And really there was not much talk about settlement. And so ultimately, a couple months ago, Judge Rosenthal, the federal judge, issued an order that said, look, if this is clearly unconstitutional, you're not following the law. In 1987, you agreed, Harris County, to do all these things and to take into account people's ability to pay. You haven't done that. And so she ordered that everyone, unless, if they're in jail in a misdemeanor, after 24 hours, unless there's some other kind of hold, you have to release them on an unsecured bond. So for the last couple weeks, ever since the Harris County moves for a stay, it was denied by the Fifth Circuit, and it was denied by Justice Thomas of the Supreme Court in an emergency stay, motion for stay. Sheriff Gonzalez has now been releasing folks. So there's no assessment tool being done here. This Arnold risk assessment tool that I'm talking about, that's coming in the future. But right now, it's like a meat cleaver. They're just going, here, we're looking at your affidavit of indigency. You can't pay up a secured bond. You're still in our jail. You're out. Now, if you got some other hold, they're going to keep you. If you got felony pending charges, if you got, a detainer from another jurisdiction, those things will still keep you in. But right now, all these things are happening. Harris County has every reason to want to do this right now, to get some control over this again, because they really don't have control over it right now. People are just going to get released. So my project in getting counsel at bail, that started, again, with the Criminal Justice Coordinating Council. We even had a subcommittee. The late L. Franco Lee set up a subcommittee. It was me, Judge Brown, Judge Harris, pretrial services, and I kept making new proposals, and they kept saying, well, but this, and it just didn't get moving. And then as I said, we had all these other things happen. And during the lawsuit, I raised again, well, it would really help if you had lawyers there. At least then you could say somebody is bringing up whether or not the defendant can pay. And finally, these big fancy defense firms, Gardner-Wynn and Winston Strawn, who represent the county, they go, that sounds good. And so all of a sudden, I was their hero. I was like, oh, and the public defender says, you can do this and this. Now, what I didn't say was, that's going to solve all your problems, because it doesn't. You could have public defenders there all day if the magistrates aren't going to listen to them and still going to say, well, there's this bail schedule, I got to follow it. You're not getting out because I'm going to set this too high so you can't get out. That doesn't solve anything. But it was helpful in that the county realized we're going to do this. So I got called over by the county attorney one day, and they said, we're going to put this on the next commissioner's court for a proposal for this. And I said, well, wait a minute. Who's agreed to this? He said, oh, no, it's a done deal. And all of a sudden there was a proposal, and I had to come back with a budget. 2 weeks later, we got $1 million. They were really motivated to do this. So, where we're going is kind of closer to what I was used to doing. I practiced in federal court. Wade and Genesis have practiced in federal court. That's what Judge Rosenthal was used to. She was used to a system where there's a pretrial officer, they do a full interview, you get the report, you go to initial appearance, you make a proffer to the judge if they want to try to keep him in, because federal courts have preventative detention, Texas doesn't. Then you got to have a full-blown hearing, you might have witnesses. That's what the federal judges are used to. That's when Judge Rosenthal heard about what we do in Harris County. No lawyers, people basically locked up by video. You can imagine she was probably pretty upset about it, and upset about Harris County's attitude, which was, oh no, we're right, you're wrong, please fix this. So my experience in my past was having contested bail hearings, or what we call detention hearings in federal court. And they were very different wherever I went. I practiced in the Southern District of Alabama, in the Eastern District of Texas, in Northern New York. Some places they let us, I got permission to sit through the pretrial interview, and we advocated there. But hearings were much more in-depth in federal court. And it's really important, like the first detention hearing I ever had, that's when I was in private practice in Houston. I used to practice with Edward Millett, who's, some of you know, you don't see him around as much as you do, but back then he was president of TCDLA, was eventually president of NACDL. He's a nationally recognized lawyer, and he did a lot of business. He had a lot of drug cases, and we would get calls from some lawyer in Cali, Colombia, who needed someone represented here in the United States back in the late 80s, early 90s, and there'd usually be several defendants. So the other lawyers would be folks like, David Byers and Kent Schaefer and folks like that. So my first detention hearing, I was sent over to federal court with Kent Schaefer, and we had co-defendants. And some of you know Kent, he's a pretty laid-back guy. And we had this hearing, and these guys were Colombian nationals. There was no way they were going to get out. There was a lot of dope. But we had this full-blown hearing. And at one point, I remember the agents were saying, well, they knew we were following them. And they had stopped at some Shipley's Donuts, I think. And Kent, without even cracking a smile, says, "Officer, do you think someone trying to invade a law enforcement officer will go to a donut shop?" Of course, you know, it's just Kent having fun. We weren't going to win that hearing, but I think what I got out of it was, you know, the clients thought we were fighting for them. They respected that. Imagine what clients, at least to date, think about Harris County. They go to this video proceeding, a magistrate yells at them, and then they go back to a holding cell. I mean, that's their first, if they've never been in the system before, that's their first impression of justice. So one of the things we hope to do is at least give people some confidence in the system. You know, confidence in lawyers, that lawyers might actually do something for them. And you can do something for them. I mean, I had a hard time convincing these judges that actually lawyers can help. But I mean, if there's a lawyer there every day, after a while, the judge is going to listen to them once in a while, okay? Even if they're just don't want to. They're going to hear something, and it's going to change their mind every once in a while. So I think just the advocacy, but just making it a fair system, making it appear to be a fair system, not having defendants have to speak for themselves and incriminate themselves is a huge step forward. So they gave us about $1 million to do this, and we've hired lots of lawyers to come help us, 6 lawyers. We may even hire a 7th at some point. We're going to have an administrator help us. We have to figure out schedules. We have to figure out procedures, protocols. You know, I've had meetings with the sheriff. The good thing is our new sheriff, Ed Gonzalez, is totally 100% supportive. I mean, I can't even imagine doing this under Sheriff Hickman. But, I mean, they will give us carte blanche to do whatever we need to do. So we'll be thinking about how to do procedures. We're going to be thinking about, we've already got space over there. We're going to do some dry, you know, this isn't going to just happen on July 3rd. Okay, we're going to do dry runs about how this all works. We're going to come up with protocols for how to do this, what information we're going to keep. I'm not going to try to cover all that today because it's a work in progress.